Good morning, my name is Michio Hansen and I stand here presenting on behalf of the Queensland Surf Life Savings and their respective clubs. The legal issue I'll be engaging today encases the liability of negligence in question to either the individual lifesavers or their otherwise respective life-saving clubs, specifically to scenarios where personal injuries are taken in occurrence of rescue operations. Such issues arise to the very nature of lifesaving. Our surf lifesavers are trusted upon volunteers who serve in the patrolling of our beaches and prevention of drownings, often at the high stake of personal risk and liability. In Queensland, thanks to their service, thousands of rescues are performed every year. Whilst the overwhelming majority are successful, accidents and injuries are an inevitable consequence. Where rescues go wrong, victims may be left in conditions injured or otherwise worse than having been rescued. Such bears to the central question of this case, whether a given injury claim lies against individual lifesavers or consequently against the organisational authority responsible for their training and supervision. This question strikes to the fundamental balance at the heart of tort law: the compensation of the injured, the protection of those guarding essential public services, and the preservation of broader societal interest. In light of this, my central argument lies in Queensland law, whilst appropriate in the shielding of volunteers through statutory immunity, currently tilts to an unjust balance against injured victims, as such demanding for subsequent reform in the guarantee of greater organisational accountability and the exploration of alternative compensation mechanisms. Throughout this presentation, I will structure the following trisects. Firstly, to the current state of liability pertaining duty, breach, causation, and defences. Secondly, to critique to whether current balance is appropriate. And thirdly, to suggest reforms in light of tort law and comparative compensation systems. Now to the state of liability. As to duty of care, under the Civil Liability Act 2003 of Queensland, acting volunteers are widely immune against claims of personal liability when, under the Act of Good Faith for community organisations. Specifically, Section 39 of the Act provides that a volunteer does not incur personal civil liability for any act or omission done or made by the volunteer in good faith when doing community work organised by a community organisation. The effect of this Act pertains to the defence of individual lifesavers from being directly held against negligence claims. Rather, liability, if any, is attached responsible to their respective clubs, treated as a relevant defendant. Such position reflects the conscious legislative policy's encouragement of volunteer participation without the threat of personal litigation. At the common law level, a duty of care posits both the foreseeability of harm with the presence of relationship warranting legal recognition. A test for recognising new categories of duty was displayed through the High Court in Sullivan and Moody 2001, where policy concerns were determined a precedent to be considered. Generally, courts are reluctant in their imposition of duties where it would expose defendants to an indeterminate liability or confliction to broader societal values. Such reluctance is highlighted through cases such as Agar and Hyde of 2000, where rugby players injured in midst of a match sued against the International Rugby Board, the IRB, alleging to unsafe rules and regulation. Following, the High Court had to refuse the imposition of duty, rationalising that bodies only within regulatory control cannot be burdened to the threat of open-ended liability. Whilst Agar had arisen within the sporting context, the underlying principle remains relevant. Life-saving clubs cannot serve to guarantee the certainty of safety under inherently dangerous rescues. However, unakin to the International Rugby Board, life-saving clubs do attain direct control over adequate training, supervision, and operational protocols. Such control strengthens the case in recognition to duty of care owed upon a club to those in need of rescue. In contrast, Loans and Woods of 1996 had imposed the liability of a doctor who in presence had refused the assistance of a child in medical distress. Through such, the court had recognised to an imposed duty on basis of proximity, reliance, and general professional reliability. Lifesavers, whilst acting in volunteerance, are similarly held reliable in the attempt of rescue to drowning victims, who otherwise have no ability to protect themselves. Such reliance weighs heavily to the favour of recognising duty. Now to the breach of duty. The standard for determining breach is characterised under the Common Law Act, Section 9 of Queensland, positing to the court's requisite to ask whether a reasonable person in a defendant's position would have taken similar precautions against the foreseeability of risk. Specifically, under Section 9, subsection 2, outlines the four fundamental considerations. Firstly, to the probability harm would occur if care were not taken. Secondly, to the likely seriousness of the harm. Thirdly, the burden of taking precautions to avoid the risk of harm. And finally, the social utility of the activity that creates the risk of harm. Once applied to lifesaving clubs, these factors delegate a delicate balance. Whilst on one hand, the probability and seriousness of harm under surf rescues is of high stakes, drowning is more often a fatal alternative. On the other hand, the burden of taking precautions, elaborated through extensive training, advanced equipment, or the service of constant patrols, may be a prohibitive factor for volunteer organisations. More significantly, the social utility of lifesaving is immense. The court's weight of foreseeability against practicality and policy is reinforced through the High Court's decision in Verey and Wyong Shire Council of 2005, alongside Roads and Traffic Authority and Dedner of 2007. Through Verey, the court had recognised that councils cannot bear responsibility in the elimination of all public beach risk. Similarly, through Dedner, it was held Roads Authority cannot be negligent for the prevention of diving injuries, given the obvious nature of the risk. Such cases highlight the attention of the case. Lifesaving clubs cannot be reasonably held in the guarantee of perfect safety, but may still fall within the breach of duty where training or procedures fall outside of a generally accepted community standards. Academic commentary furthers in the strengthening of this critique. Through Dietrich and Field, it was argued that the reasonable person standard may be deemed unjust where the case of the plaintiff is uniquely vulnerable to their conditions. Victims to drownings cannot be under the mitigation of risks themselves, with their survival dependent entirely upon the duty of lifesavers. Thus, in the evaluation of breach, courts should subsequently set a correspondingly high bar owed upon organisational standards. Next to causation. Per Section 11 of the Civil Liability Act of Queensland, a plaintiff is required to establish negligence as a necessary condition having amounted to the harm incurred, in turn extending the liability to that harm. Such inferences introduces elements of both factual causation and the scope of liability. In rescue cases specifically, causation can be complex. In the case a lifesaver mishandles a spinal rescue, only contributing a worsened state of the victim's injury, would the harm have been caused as a result of the ocean conditions, the victim's own panic, or the negligence imposed by the rescuer? Observing Norfolk and John Vick of 2005, it's reinforced that causation more often turns to whether the risk was of an obvious and unavoidable nature. Policy-driven causation is exemplified through March and Stamar of 1991, where high courts had emphasised causation as not merely amounting to mechanical, but rather normative, having been shaped upon value judgments. When applied to this specifically, courts may limit the findings of causation in the avoidance of discouraging rescue attempts from lifesavers. Now to defences. Through the Civil Liability Act, several defence options are provided. Firstly, to volunteer immunity, per Section 39, specifically shields individual lifesavers. Secondly, to dangerous recreational activities, per Section 19, which excludes the liability of harm when under the aspiring obvious risk relating to dangerous recreational activities. However, its application when applied to rescue operations is widely contested, where drowning victims rarely come under the assumption of risk related to negligent rescue. Thirdly, to obvious risk, per subsection 13 to 15, where harm has arisen from risk obvious to a reasonable person, liability may be shielded by the bar. Similarly, in rescue emergencies, victims rarely have the choice nor consent to the administering of those risks. Such defences serve in significantly restricting claims, especially when combined with the court's reluctance to expand duties. Injured parties may be left uncompensated. Now to the critique of the current balance. The current legal framework prioritises in the protection of vulnerable and the limiting of organisational exposure, reflecting the policy objective, encouraging, not diminishing, volunteers' participation amongst surf lifesavers. With such statutory immunity, a fear of litigation would deter the service of volunteering, undermining the essentiality of the community service. Whilst an excellent precedent for volunteers, this protective stance comes at a cost to injured victims, facing significant medical expenses and compensation loss. Unakin to workers having been injured within their workplace or motorists injured amidst roadside accidents, victims of negligent surf rescues face vicarious loss. Where the balance therefore stands irrevocably unjust, where volunteers engage full immunity, clubs may face partial liability, although often invoking statutory defences, and where victims consequently bear the greatest loss, withholding scarce avenues of redress. Such imbalance directly undermines the compensatory functions addressed to tort law, bearing to question the distributive justice concerns. Why should those unlucky enough to have been injured amidst a surf rescue be left in a worse off state than those injured under comparative context, where compensation schemes exist? Now to suggested reforms. Firstly, to clarify organisational liability. An amendment should be made per the Queensland Civil Liability Act, such to expressly define circumstances where community organisations owe a duty of care. In doing so, a clear statutory framework would foster in the upholding of consistent outcomes and the prevention of clubs escaping their lengths of liability through current narrow interpretations of duty. Secondly, to limit volunteer immunity applied to cases of gross negligence. Whilst the current standing general immunity per Section 39 is justified, there should warrant no extension of the defences when partaking cases of reckless gross negligence. Numerous international jurisdictions, including North America, specifically distinguish between the case of ordinary and gross negligence when deciding for volunteer cases. It would be best applied with Queensland adopting a similar approach. Thirdly, to the introduction of a no-fault compensation scheme. The most effective forms of reform partake statutory compensation funds in rescue-related injuries, jointly funded per governmental and surf lifesaving grants. Such schemes already exist to operate, such as through the Transport Accident Commission in Victoria, where a no-fault compensation is addressed for road-related accidents. The emergence of a rescue injury fund would function in the assurance of victim compensation without the pressure of volunteer litigation exposure or the deterrence of participation. And fourthly, to the tort theory justification. From the perspective of economic efficiency, a shifting of loss to compensation funds serves to internalise the social aspects of lifesaving, whilst maintaining the participation of volunteers. From perspectives of corrective justice, a quality of fairness demands that victims do not bear the entire burden of rescue accidents, when society as a whole benefits from the collective efforts of life-saving services. From the perspectives of distributive justice, the spreading of costs throughout society is a more equitable alternative than the concentration of fees upon already unlucky individuals. To summarise, currently standing of Queensland law imposes the immunisation of volunteers per the Civil Liability Act 2003 of Queensland, Section 39, which negates individual lifesaving clubs as the primary defendant to negligence claims. Courts are notoriously cautious in the opposing of duties, influenced through the previous cases of Agar and Hyde, Vary and Dadura. Whilst the current system works in the protection of social utility provided by lifesaving, it often succumbs to compensatory of victims, materialising as an imbalance. As such, the central argument to this case pertains that whilst individual volunteer immunity should be generally remain, the balance of such should be consequently recalibrated. Narrower immunity in a gross negligence case, more defined organisational accountability, and the establishment of a rescue-related injury compensation scheme would together contribute to a fairer, more sustained balance in the protection of lifesavers alongside the compensation of victims, a balance serving the interest of society today. Thank you.